Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome back to the FIA Group's Empowering Plans Podcast. This is Jon Jablon. I'm an attorney with FIA and the director of our consulting services. And with me today is Nick Bonds, another attorney with FIA in the consulting department. And when I asked Nick what his job title was, just so I could introduce him, he said, I think it's just sort of attorney or maybe PGC attorney. So it's a little bit unimaginative, and I would encourage all of our listeners to write to Adam Russo or Jen McCormick to let them know that Nick needs a better job title. So I have been with FIA going on almost 8 years at this point, 8 just magical years. It's really been great. It's been an incredible learning experience. Nick, how long have you been with FIA?
I started with FIA right at the end of 2018. So it feels like it's been about a decade for me, but it's only been about 2.5, 3 years.
That sounds about right. So yeah, Nick is incredibly knowledgeable about a lot of things. I just didn't know what his job title was because that's not something that I've ever really had to pay attention to. But I can honestly say I'm not entirely satisfied with what he told me. So please, like I said, write to Adam or to Jen or even to Ron Peck and let them know that Nick needs a new job title. So thanks again for joining us today. We are going to be talking about a topic that is near and dear to a lot of our listeners. It is almost as popular as COVID reopenings. It is not quite as dramatic as some of the other stuff going on in the world, but it is just as important to a lot of health plans, and that is NQTLs, or Non-Quantitative Treatment Limitations, and the analysis that must be performed pursuant to the, and here's a mouthful, the Mental Health Parity and Addiction Equity Act. I think, or I'm going to do my best at least on this podcast to not talk about that in terms of its long name, the Mental Health Parity and Addiction Equity Act, but instead we might call it the Mental Health Parity Law or the Act or simply just the law because it's easier for us to say and it's easier for you to hear. And frankly, I don't want to trip up every time I try to say it. So we're going to go with that. And I guess
Jon, I don't know what you mean. I don't understand why the MHPAEA feels like a mouthful. How could the MHPAEA possibly get muddled or confused in an audio format?
I'll tell you what, Nick, why don't you say the acronym 10 times fast?
MHPAEA, 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 MHPAEA. You kind of hit a rhythm with it. MHPAEA.
That's actually much better than I expected. All right, so every time I want to say that, I'm going to kick it over to Nick and ask him to just say it 10 times fast.
Great.
So for some brief background on what this entails, the NQTL analysis, and of course, we will get into what NQTLs actually are and what this analysis is. But as some quick background, the Consolidated Appropriations Act was passed somewhat recently. And basically what it is the DOL has promised to look more deeply into mental health and substance abuse claims. Obviously, there's much more to the CAA than just this mental health parity stuff, because it also encompasses that thing we all know and love, the No Surprises Act. That is another topic, or maybe another 10 topics for another day. But today we're going to be talking about a part of the CAA, which is new mental health parity laws. So like I said, the DOL has basically been, let's say, unsatisfied with how health plans may be treating their mental health parity equivalencies. And they have promised to look deeper into it in 2022 and actually probably part of 2021 as well. And as part of the CAA and the No Surprises Act, in case you haven't really been involved in this at all so far, federal law has recently provided much greater protections for plan members, participants, patients, whatever you want to call them. They're getting more protections all the time. And with protections for plan members, of course, comes protections for medical providers. Because when it comes to protections for plan members, most of what we're talking about is how much the plan pays. A lot of it is information that is given to patients, but so much of it just has to do with how much the plan pays and therefore how much the provider might charge the patient. So with greater transparency and greater health plan accountability, of course, comes greater responsibility for health plans and greater protections for patients. it's hard to not be on board with something that broad, but when we look more deeply into it, of course, there are some significant burdens placed on health plans, right? I mean, as every federal law gives us, there are more hoops that they really need to jump through. And the new regulations as part of it, it's certainly no exception. So, if nothing else, the No Surprises Act, which is part of the CAA, that's proof that the CAA is generally pro-patient and pro-provider rather than being pro-health plans, right? Just like ERISA, it gives the plan certain rights, but ultimately it imposes a lot of responsibilities. And the NQTL analysis is just another, I don't want to say a huge responsibility, but it's significant. It's definitely something that health plans will need to be concerned with to some extent. So the question arises, right? What are NQTLs? What the heck are we talking about? What is this analysis analyzing? NQTLs, non-quantitative treatment limitations. Those, of course, we can compare to quantitative treatment limitations. The only difference is that word non. Quantitative treatment limitations, as you might expect, are things that you can count. The difference between two coinsurance amounts, for instance, 90% and 80%, that's perfectly quantitative. There's no question that 90% is more than 80%. And in fact, we know exactly how much more it is. Or treatment limitations. For instance, if you allow 30 days of a treatment versus 60 days of a treatment. Again, no question, it's quantitative. We can measure those numbers. We can plug them in a calculator. It is easy. Same thing goes for something like age limitations. For instance, if you're not providing a service to people over the age of 16, or if you are providing a service to people over the age of 16, that's quantitative. You can count to 16, or at least we think you can anyway. I mean, with all this regulatory stuff going on, I know my head is spinning. I don't know about you.
So I can on a good day. On a good day, I can usually hit at least 16.
But realistically, how many good days do you have?
40%, I think, of days these days.
What a nice quantity.
No, it's a little higher. A little higher.
All right. So Nick, do you want to give some examples of NQTLs?
Yeah, absolutely. So it's important to remember that just like the quantitative limitations, the NQTLs are going to be subject to the mental health parity law, the MHPAEA. And it's easy to kind of see, like Jon was saying, what a quantifiable treatment limitation would be. It's literally quantifiable. It has a number attached to it, essentially. But non-quantitative treatment limitations, they're actually a little more nebulous, and they may realistically be a little more common. So they include things like medical management or utilization management requirements. Anytime a plan applies their definition of experimental or investigational, or applies a definition of medical necessity to a benefit, that's sort of a non-quantifiable treatment limitation. There's no hard number attached there, so it's non-quantifiable. That can also include things like network access, network standards, including, what the network rate is that applies to a benefit, or just which providers are included in a plan's network. And also, the flip side of that is that the out-of-network rate that a plan applies to these benefits could be non-quantifiable, because it's harder to put a number next to that sometimes, especially if a plan is using something like a percentage of Medicare or a percentage of some external guide. It may be hard to put a precise number to that. Other things can kind of factor in too, like if a plan is applying a drug formulary through their PBM, that might be an example of a non-quantifiable treatment limitation. There are a few other things that we recently saw in a case out of Northern California. Is that right, Jon? That was trying to limit ABA therapy?
That's right. It was a federal district court in the Northern District of California. Basically, what happened was, it was actually a very interesting case. This health plan excluded ABA and IBT treatment altogether. And ultimately, what the court held is that it does, in fact, violate the Mental Health Parity Act, because as a QTL, a quantitative treatment limit, you allow 0 visits. Well, yeah, if you exclude something, I guess you're allowing 0 visits. It's a really interesting way to look at it. And that's what the court said. The court said, yeah, no, this is a quantifiable treatment limitation, because 0 is, in fact, a number. And it's especially interesting because the court went into sort of some high-level basic mathematical theory around the number 0. They quoted some external sources. They got sort of in-depth with how 0 is really a number. Really interesting stuff. But they also said that it was simultaneously a non-quantitative treatment limitation, because what you're doing is excluding the primary treatment for autism spectrum disorders. So while you can count the number of treatments that this plan allowed, which of course was 0, you can't count the fact that they excluded the primary autism spectrum disorder treatment, but in fact it did happen. So it's not a number there, it's just one of those, to use the word Nick used, those nebulous non-quantitative treatment limitations. And I love that word so much, nebulous. What a great word. It makes me think of space, but at the same time I think of what it actually means, and then I'm basically distracted thinking about space for a while, but that's just me.
We're gonna veer into real ethereal territory debating the reality of zero and what is space.
No kidding. You know, in college, I studied linguistics, and part of that was mathematical philosophy. And we actually talked a lot about zero and the different notions of the concept of zero that they had. So when I saw this case, I was like, oh, this is especially interesting because it's actually something, deeper than just the law. It's philosophy. It's great. But that's another topic for another day. I guess if anybody wants to have an in-depth conversation about mathematical philosophy, just let us know.
Yeah, into Adam. And please engage him. And
perfect.
I think something really interesting about that case, though, is that notion that the total exclusion of a benefit is itself a treatment limitation kind of runs contrary to our typical understanding, and I think even runs contrary to DOL guidance that basically says the permanent exclusion of the type of benefit isn't a limitation for purposes of the mental health parity law. Is that right? The case is sort of an anomaly so far from what we've seen.
Yeah, I think that that's actually part of the additional guidance that we're expecting to get. The regulators gave us some examples of quantitative treatment limitations and non-quantitative treatment limitations, and it doesn't all completely jive with our previous understandings or even our concurrent understandings, right? So we're dealing with some varying guidance, and I am inclined to advise our clients to rely on what they have said most recently, just if you have to choose, which apparently you do. So if you have to choose, I would say go with what they put out as part of this particular set of regulations, but we are expecting further guidance. And in fact, the law already has required the regulators to give us more guidance within, what was it, Nick, 18 months of the law's passage?
Yes, I think the law passed December 27th. So hopefully sometime before mid-summer next year, we should get some more firm guidance on the requirements.
Knowing the DOL and HHS, we will have it basically June 28th or June 27th.
Right. Yeah,
or
most likely.
But yeah, it's definitely raising some questions. And that's actually part of the great difficulty that health plans are having in deciding, well, do we need to do this analysis? How do we do it? What the heck are the regulations even talking about? Just another question to add to the long list. And actually on that topic, we've got a bunch of questions here ready to read and hopefully try to answer questions that our clients have already asked us on this law. It's end of May. All right, so this has been around now for almost 6 months, and we've already gotten a ton of questions. We've got a lot of plans that are looking to perform this analysis and just trying to figure out logistics of how. And Nick, I'll pose this one to you. For ERISA compliance, does it matter if a benefit limit constitutes a QTL or an NQTL? And remember, that's for ERISA compliance. What do you think, Nick?
From an ERISA perspective, not so much. The mental health parity law, it requires the analysis only of the NQTLs technically. So to comply with the MHPAEA and this comparative analysis requirement, you don't have to analyze the quantitative treatment limitations. But from an ERISA perspective, this doesn't really change anything. It doesn't really impact how ERISA views these sort of benefits and their limits.
Yeah, my impression of the reason that the Mental Health Parity Act requires an analysis of non-quantitative treatment limitations, but doesn't require an analysis of quantitative treatment limitations, I have assumed, and I don't know about this, but I have assumed that it's because quantitative treatment limitations, they don't really require any analysis. They're just written there in the plan. You can compare 90% versus 80%, no analysis needed. But the non-quantitative treatment limitations, they're not so cut and dry. They are more wordy and less number-y, for lack of a better word. So they
more
are
nebulous, you could say.
More nebulous. I didn't want to say it again because I didn't want to be that guy. All the time. But yeah, they are definitely more nebulous, and an analysis can help the average participant as well as the DOL sort of figure out exactly what's going on with them. Whereas with the quantitative treatment limitations, like I said, you just don't need an analysis. All you need to do is look at two numbers and compare them. So that's at least my take on why the NQTLs are different from the QTLs in terms of enforcement. But absolutely, I agree, Nick. With respect to ERISA, there's no difference, right? The Mental Health Parity Act draws a distinction, but ERISA itself, it's just sort of ordinary health plan legislation, kind of as it's always been. Now, the Consolidated Appropriations Act does unequivocally add certain terms to ERISA and HIPAA and expands them a bit, but nothing regarding mental health parity. There is nothing with respect to NQTLs that would bring a plan out of compliance with ERISA, assuming that plan was, of course, otherwise compliant.
I think you're definitely onto something there, that it's just the fact that a quantitative treatment limitation would have a fairly straightforward analysis, at least in theory. That makes a lot of sense.
Right, which actually brings me to another question. And I've actually got a list of questions here to ask Nick, and they sort of flow. But because you said that, I want to jump down to a question about what if a plan pays, for instance, mental health benefits at 90% without a deductible, but pays medical and surgical benefits at 100% with a deductible. The deductible and coinsurance are both numerical, right? So that leads me to believe that they are probably quantitative, but at the same time, if you're applying different standards to different types of claims, how do we measure apples against oranges? And does that make them non-quantitative after all?
Well, that's sort of a gray area under the MHPAEA. I think what we would have to say, though, is that there's no exception under the MHPAEA for the kind of apples to oranges comparison. If the deductibles are distinguished between the benefits, then you would maybe lean towards calling it a non-quantitative treatment limitation, but there's no exception under the comparative analysis requirement for something that's probably not non-quantitative. So it's probably better to err on the side of analyzing it. And if it fundamentally is more of a quantifiable treatment limitation, then your analysis, like we just mentioned, is probably going to be very straightforward. So it's sort of a gimme under the requirement.
Yeah, I think that makes sense. And, generally, I don't believe that there's anything in the mental health parity law with respect to the NQTL analysis. I don't think there's anything in there that says that if something is questionable or maybe you're on the fence about whether it's an NQTL, if it ends up being quantifiable, I don't think that there's anything in there actually prohibiting you from including something quantifiable. And frankly, you might find out very quickly that it's quantifiable because your analysis will be incredibly simple. Your analysis will be, well, 90 is more than 80, so great. But not everything is quite so simple. So in the example I gave, where one benefit is paid at 90% with deductible and something else is paid at 100% without deductible, I think even the potential that one of those benefits might be greater than the other, because of course you don't know what the deductible is in any given claim until it comes in, right? Because one participant may have met her deductible while another one might not have. So paying something at 90% without deductible or 100% with deductible, they might end up being the same, or either one might be more than the other. We just don't know. It depends on the size of the claim and the actual deductible that is left in that participant's account. So when in doubt, call it an NQTL. That is our general advice from FIA. And of course, we have to give at least one shameless marketing plug during this podcast, right? If you are in need of an NQTL analysis, please contact us. info@fiagroup.com is a great resource. We can get you anything you need. So end shameless plug.
Another thing that occurred to me, John, even where the plan language appears to be applying quantifiable treatment limitations as written, if the practical, on the ground impact of those limitations can have a non-quantifiable impact, if the limitation in practice has a potentially non-quantifiable limiting effect that itself be a potential mental health parity violation, that's the kind of thing you need to perform the analysis to kind of tease out, and that's the kind of thing that I think the DOL is going to be looking for. So even if it on paper is a quantifiable treatment limitation, it's well worth doing the analysis just to ensure that there's not a potential parity issue there.
Yeah, that's a really good point, Nick. And we will talk about sort of what happens if you don't have this analysis ready when you need it. But yes, definitely relevant. And not performing the analysis is pretty similar to only performing part of the analysis, right? If you leave out a bunch of NQTLs or things that turn out to be NQTLs, even if you didn't realize, you have not performed the analysis exactly as you are supposed to. So that's, I think, part of the guidance that we're going to get is what happens if you do the analysis, but you maybe leave something out, whether it's unintentional or not. I don't know if the regulators are going to care, but if you haven't done the analysis in full exactly as they intend, I think that right now, the general guidance is that, well, then you haven't done the analysis, and that can be really dangerous. So another question we've gotten is, do we have to perform the analysis if this plan pays everything, all benefits, medical, surgical, mental health, substance abuse, if the plan pays everything at 100% with no deductibles? So basically, I think the gist of the question is, there are no real non-quantifiable treatment limitations in terms of the amount of payment, because everything is paid at 100%. We don't ask what the service is. As long as it's covered, it's paid at 100%. Well, generally the answer seems like it might be, oh no, you don't really need the analysis because there's not much to say. But in reality, think about everything we've been talking about. Payment rates, deductibles, and coinsurance, not the only things that can constitute NQTLs, right? A plan that pays everything at 100% with no deductibles, that's fantastic. But there's probably still some element of pre-cert. There's probably various utilization management protocols. There's probably all sorts of fun stuff that could constitute NQTLs. So even if the plan looks like everything is quantifiable, I can virtually guarantee that not everything is going to be quantifiable. So there's no exemption from the NQTL analysis requirement for plans that appear to not have any NQTLs. And that's probably just because the regulators are assuming that every plan is going to have some sort of NQTLs. And look, if you don't, that's awesome. Good for you. I can't really imagine a scenario where there would be literally no NQTLs, but if there are no NQTLs whatsoever, I guess my general advice would still be do a very short, truncated analysis and just show that. Because if somebody asks you for the analysis and you say, we didn't do it, they're not going to say, why not? They're going to say, oh, you're in trouble. And that's sort of the general framework that we're working with right now.
Yeah, I think that's the key where you said just show that. The whole point is if you don't have NQTLs in place, I think that the DOL would still say like, okay, prove it. So you still need to have something on hand that can show that the plan has looked at their benefits, looked at their limitations, looked at how they're applied, and can, show their work, I think is the phrase we've been using, that a plan can basically prove to the DOL's satisfaction that they are basically offering these benefits and have these limitations that are in compliance with the mental health parity requirements.
Right, and this is actually probably a really good time to mention, because we haven't said this before, we probably should have led with this. There's nothing wrong with NQTLs. Well, there's nothing inherently wrong with them anyway. They can be applied in a manner that violates the Mental Health Parity Act, or even sometimes as the plan is written, that might violate the Mental Health Parity Act. There's nothing inherently wrong, however, with NQTLs. Like I said, every plan is going to have some NQTLs, and it's not necessarily a bad thing. So just like in, middle school math class, you've got to show your work whether you get the answer right or wrong, right? It's not only showing your work if the answer is wrong. You're not just proving that you messed up. You're also proving that you got it right and that you know what you're doing. And as far as we can tell, that is exactly what the regulators are looking for. They're looking for plans to prove that they're compliant. And that's one of the reasons that it's so important that everybody does this, because it's not that you only need to do it if you might be non-compliant. You need to do it to prove that you are compliant. And that goes back to what I said before about how the DOL has specifically said that in the coming year or so, they're going to make mental health parity a real focus area. They're going to crack down, I don't know what extent or exactly how that's going to manifest itself, but they are really going to start looking into this more than ever. So that's something that plans really need to sort of be aware of. And of course, health plans themselves are going to rely on their TPAs and brokers and consultants, et cetera, to get this stuff done for them. So we talk a lot about health plans. Of course, the plan is relevant to the analysis, but most of the folks listening to this podcast are not health plans, but folks who service health plans. And you, health plan servicers, are the ones who are going to be tasked with getting these analyses done, making sure your plans are compliant, and otherwise doing things that the plans are really responsible to do, but we know who really does them. So it makes sense now, Nick, to talk about what happens if you don't do it, or if you bide your time, or if it's not done correctly. So do you want to kick that off?
Yeah, absolutely. So I think we've had a few plans that have basically said to us, hey, this looks like a lot of work. We're not really in a position to deal with this right now. We're going to kind of hang out until it becomes an issue, because the way the requirement is worded, it's not something that you have to affirmatively turn in. There's no specific due date for this analysis. But the important thing to remember is that the analysis has to be provided to the DOL or to a state regulatory agency upon request. And importantly, any ERISA plan participant would be able to invoke their ERISA rights to also request this analysis. So there's sort of a hair trigger on the need to get this analysis put together and provided quickly. So the DOL basically gives plans a notice saying, hey, you have to provide this analysis. Plans turn over what they've got to the DOL, and the DOL will take a look at the analysis they performed, and they'll either decide if, one, the analysis is sufficient, or two, if the analysis indicates that there's a mental health parity concern. And if either of those are true, the DOL will send the analysis back to the group, and they'll say, all right, try again, you have 45 days. And even that 45 days is not a lot of time to put a full analysis together, especially more complex plans that might have multiple plan servicers, that might have a PBM and might have a dialysis carve out and might have different network administrators and TPAs and maybe even a separate COBRA administrator. Those plans are going to have to go to each of those entities to get all the necessary information compiled on these NQTLs. And that could take a long time. So we definitely don't recommend waiting until you get a request, be it from a plan participant or from a state agency, or God forbid, the DOL comes knocking with an audit. We really don't recommend you wait until you're under the gun, as it were, to provide the analysis, because the more of a time crunch a plan is under, the more likely it is that there's going to be something that the DOL kind of bumps on and decides is either insufficient or non-compliance. And if you get on the DOL's radar, they tend to not let you off their radar. So they're going to keep coming back and focusing on plans that kind of hit this tripwire and probably come knocking multiple times down the road. So don't paint yourself into that corner. Be proactive about performing this analysis and kind of getting all your ducks in a row so that this doesn't become a much bigger issue down the line. Well, Jon, I think you and I have sufficiently talked up the potential headaches of the comparative analysis requirement and some of the complications that could arise from trying to perform it. To sort of wrap it up, we would just say we're here to help. We're happy to be a resource and an assistant and a guide to plans the best way that we can. Anybody listening to this podcast who has more questions, feel free to reach out. Probably the best email address to use for us right now would be info@feagroup.com. Other than that, Jon, did you have anything you wanted to wind up with?
No, I don't think so. We've been analyzing this a lot. We've got some ideas of some practical effects of the analysis. We would be more than happy to have a conversation with you if you've got thoughts or concerns or questions. I mean, we've got thoughts and concerns and questions ourselves. So we're happy to, to bounce around ideas with anybody who wants to. So by all means, feel free. If you are in need of an analysis or just want to know sort of what it entails, like Nick said, info@feagroup.com. That's info as in information. Just let us know. We're always happy to help. I mean, those of you who know the FEA Group know that we are in the business of helping health plans and empowering plans, and this is the stuff we love. So thank you all so much for listening. I know that we've taken up quite a bit of time, but frankly, it's a big topic and there's a lot to say and probably a lot more that we could have said, but lucky you, we're going to spare you this podcast. So thanks again, and we hope to see you back for our future podcasts.
Yeah, thank you, Jon, and thank you, our man in the chair, Pat Santos. We appreciate you, buddy.
Take care.